Thank you, Mr. Chair. My questions are for Anna Maria. The first one is, I've noticed that African Canadians are pretty well absent from the debate in terms of their own voices in the debate, but also in terms of a lack of consultation with the African Canadian community. And when you look at, and you've both mentioned this in your submission, the overrepresentation of African Canadians in being incarcerated, and many because of simple possession. So could you tell us why you think that is the case? Why is that so?
That's a very complex question, but I think that I agree with you that Bill C-45 is blind in its inability to recognize and treat and deal with the disproportionate way in which the war on cannabis and in which the war on drugs in general has targeted and negatively impacted the lives of racialized communities, particularly African Canadian communities, African Canadian people in Canada. And it's disappointing because the impetus for the law was to reduce criminalization, unnecessary criminalization, and nowhere is that unnecessary criminalization more apparent than among the individuals that exist in this community. We know that through the exercise of discretion in the laying of charges, in arresting and in prosecution, individuals who are from marginalized or racialized communities are more likely to be arrested instead of given a warning or dismissed on the street. They're more likely to be denied bail. They're more likely to receive harsher sentences, and as a result are more likely to have criminal records that will follow them for the rest of their lives and will further marginalize them by impacting the way in which they can, or limit the way in which they can become meaningful members of society. And I think that the reason that this glaring error is present in Bill C-45 is because the bill, I think, along the way, kind of lost its way. It began, and I believe the first draft of this bill that was tabled by this government included a provision that made way for pardons for individuals with prior simple possession offenses, and that provision was removed. And in my perspective, and in the perspective of many criminal defense lawyers that are working in this area, this is an ill-conceived amendment to the bill because it doesn't address the individuals who are actually the most impacted by the criminalization of the substance in society. And if the effect of this bill, or if the purpose of this bill is to remove or change or somehow rectify this historical injustice, it doesn't make any sense for them to be excluded from the bill. And why I say that this bill has lost its way along the way is because increasingly, as the bill went through, it appears to be more focused on making a cannabis industry that is profitable for the most privileged in society, rather than making cannabis or cannabis convictions something that doesn't have the effect of negatively impacting and destroying the lives of individuals that have come in conflict with the law in the past. And so I think the focus of the bill has gone askew, and we really must, if this is a social justice measure, we really must go back and readdress the way in which the criminalization of cannabis, or the decriminalization of cannabis, or the legalization of cannabis in this case, does not address these individuals who are the most vulnerable and most impacted by the history of prohibition.
Is there time to add a supplemental?
Just a very quick one.
Very quickly. So wondering about intersectionality. I asked this question of the Aboriginal panel that was on just before you, and that hadn't come up, but I'm wondering about women from those racialized and marginalized communities, and are they differentially impacted?
Right. Women often come in conflict with the law in relation to drugs largely as, well, it's as personal consumption, but also in terms of what would be colloquially called as drug mules. And we know that individuals who have convictions on the basis of this are individuals who are in vulnerable positions, who are often in the trafficking or distribution of cannabis for the purpose of gaining an income to sustain their families and to sustain their children. So I think with in terms of the intersectionality of the criminalization of cannabis and the impact that would have on women of color in Canada, what I would say is that because of the nature in which these women come into contact with the criminal justice system, and that being by attempting to gain income for their families, what the criminalization or the further criminalization does is it not only punishes the woman, but it also punishes the rest of her family, the children who can now no longer rely on her income and her support, and in the case of custodial sentences, may often be taken into care. And so the ramifications of criminalization have particularly devastating impacts for women of color who are quite vulnerable, and especially if they are below the poverty threshold.
Okay.
Thank you.
Thank you very much. Senator Rain.
Thank you. Well, you've certainly given us a lot to think about today, and I have to confess that I start wondering how did this bill get drafted the way it is and get so far along this path. And I would have thought, I'm not a lawyer and I don't really understand how it works, but were you not, was the Canadian Bar Association and the Quebec Bar Association, Criminal Lawyers Association, not involved at all in the drafting of this legislation?
We weren't consulted with respect to the drafting, and I don't know personally of any criminal defense lawyers who were consulted with respect to the drafting, and certainly our recommendations, which are similar to the ones that we made here, weren't acted on in the House.
So when the committee traveled across Canada to get input, they might have heard from you, but they didn't listen.
The Canadian Bar Association was not consulted, and I believe it is noted in one of our submissions that there were a very limited number of submissions that were allowed in the time frame that the bill was looked at. So we were not consulted about the actual content of the
Monsieur
bill.
Levesque.
Je peux vérifier.
I could check into this, but I don't believe so. I've been sitting on the committee since 2015. I wasn't president at the time. I've been chairing the committee since 2017, and I do not believe that we were consulted when the committee held hearings. I'm saying that with the reservation that I'll have to verify this. We would have discussed it in the context of our appearance here. I don't believe we were consulted, no.
Gathering information and that we've been presented with as the raison d'etre for the bill hasn't consulted many people at all. So that's a real shame, I think, and I agree that societal attitudes need to be changed around this, but to criminalize possession is not the way to go. But I would believe that we still need to criminalize the trafficking and the illegal production and the sale of it. So is that what this law should be doing, C-45, and removing the possession effects from the legal penalties?
I think so, and I think that would reflect the submissions that we made in our brief. I would like to take this opportunity just to add one final point to our submission that actually intersects quite well with what Anna Maria was saying about discretion and how that has adversely impacted marginalized groups. A lot of people who support this bill say the concerns that we have raised about youth and about penalties and about collateral consequences can be cured because police officers can choose not to lay charges or choose to give a ticket. or prosecutors can choose one way or choose the other way. That's the very same discretion that Anna Maria talked about that disproportionately impacts vulnerable groups. And so when the committee's considering this bill that maybe wasn't properly consulted on or there hasn't been amendments thus far, I would caution this committee to discount people saying that the problems here that have been pointed out can be cured down the line with discretion, because we know that that hasn't worked in the past, and the Supreme Court recently in the case of Noor has said that the exercise of discretion doesn't cure constitutional defects, such as the ones that we've pointed out. So I think that that's very important for this committee to look at as well.
Okay.
Just a final,
It's just that
No, can we get the comments in from the other two?
advocated treating this like liquor or tobacco.
no, I-
Monsieur Levesque, you asked for all of them, so let's get them all in.
Oui, c'est tout à fait.
Yes, it's legitimate in our view to control what happens with regard to trafficking, production, and distribution. That's where the big players are. And here, from what I understand of Parliament's intention, it's banking on the fact that vulnerable individuals will either abandon drugs or they'll buy drugs that are legal and monitored by the government. As we state in our brief, we're team players, even though we haven't taken position. If that's the federal government's view, we'll do our maximum, our utmost to protect the public and go along.